This is Michael Popok, Legal AF. Well, Donald Trump and his lawyers better be sitting down because they just got an order from Judge Engoron that's actually in their favor, and an effort by them to disqualify Judge Engoron as the judge who rendered the decision after 6 weeks of trial against Trump and all of the little Trumpers for $465 million in the New York Attorney General civil fraud case. Let me bring everybody up to speed. A couple of weeks ago, the other side found out that a lawyer who regularly appears in front of Judge Engoron, in this case, a guy by the name of Adam Leitman Bailey at a law firm, got into a conversation with the judge before he entered his order against Donald Trump, his decision and order against Donald Trump, and gave his unsolicited 2 cents opinion that the judge should not rule against Donald Trump and should not fine for Letitia James, in words to that effect. The judge didn't credit it. Mr. Littman Bailey was not representing Donald Trump. It was not an ex parte communication the way lawyers know that to be, because it wasn't one of the sides in the case making contact with the judge. And so he didn't have to disclose it to the parties. But they made a big deal out of it and said, oh, it shows Engoron should be disqualified. He was taking unsolicited advice from somebody. By the way, the unsolicited advice was pro Donald Trump, not against Donald Trump. Put that aside for a minute. As part of their motion to disqualify, which goes to Judge Engoron, all judges decide their own motions to disqualify in the first instance before it goes off to an appellate court. May seem counterintuitive, may seem strange to have the judge that you think did something bad handle the disqualification or recusal motion, but that's the way it works in our American justice system. And so as part of that, they wanted a full-blown evidentiary hearing, they wanted witness testimony, and they wanted this lawyer who stuck his big fat nose and big fat thumb right into this case for no reason, maybe public glory, maybe his 15 minutes of fame, but Adam Leitman Bailey got a subpoena, and his law firm got a subpoena asking for everything under the sun, all communications he's ever had in any of his cases with the judge. He represents dozens and dozens of clients that have been before the court, having nothing to do with Donald Trump. They wanted all conversations or communications this guy, who's not involved with the case, has had with other third parties about Donald Trump. What does that have to do with anything? So this is a classic fishing expedition. And on that ground alone, the judge could quash it. But are you sitting down, Donald? Are you sitting down, lawyers? You got part of what you were looking for because the judge isn't scared by your motion practice or by your discovery. Here's what he said. He said, generally, when you do a fishing expedition for a subpoena and you're looking for things that are completely irrelevant to the matters at hand, that's going to be quashed. And the judge could have done that. But on page 2 of the order, the decision and order I have right here, it says in the third paragraph, however, the subpoena directed to Mr. Bailey and his firm is not wholly without merit. Mr. Bailey has opened the door by making his extraordinary claims to the media, in which he, by his own admission, stated that he attempted to offer unsolicited legal advice to this court. Right, he cornered the judge and started to tell the judge why he shouldn't rule against Donald Trump. By the way, he ruled against Donald Trump, if you don't know current history, to the tune of $465 million running with interest. Accordingly, the judge went on, defendants are entitled to any communications or documents in Mr. Bailey's possession that involve, discuss, or in any way refer to the case that the judge just entered the decision and order about Donald Trump as defined in the subpoena. So the motion to quash is granted in part solely to the extent of quashing any communications sought that are unrelated, not relevant to the Trump case. Mr. Bailey is directed to furnish all responsive documents to the subpoena as here modified within 7 days from the date of this order. That is a confident judge who's basically saying, bring it. I didn't do anything wrong. It's not an ex parte communication under the judicial ethics rules or the canons. It was just an unsolicited, almost setup by Bailey to pull the judge aside and then go to the media for his 15 minutes of fame. Has nothing to do with the proper, it's not a miscarriage of justice. It's not something that was improper. And the judge is saying, you want to go rooting around the filing cabinets of Mr. Bailey? You want to find out whatever communications he had about this action with the court? Go ahead. The judge knows it's going to be none. He's searched his own emails. He's made sure in his own text messages there aren't going to be any. And so it's at best a Pyrrhic victory for Donald Trump, but it just shows you how confident Judge Engoron is that he's properly administrating justice in that courtroom. He doesn't have to hide anything. You want to go get Mr. Bailey's documents? Fine. They may even next, after they get the documents, they may ask Bailey, they might ask the court for a deposition. We want a deposition of Mr. Bailey to get to the bottom of what went down. The judge will probably grant it within limits. Most clothes are uncomfortable or too tight or never actually the size you really are, not to mention the annoyance of trying to put a good outfit together. Everyone wants to dress their best and look good at all times because, frankly, it's a confidence booster. I regularly wear Roan when I do the podcast or on Hot Takes. So here's the deal. Men's closets were due for a radical reinvention, and Roan stepped up to the challenge. Roan's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Roan helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. Roan's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy what life throws your way. From your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Roan's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. With Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Roan is 100% machine washable, so you can ditch the dry cleaner altogether. Roan has truly become my favorite clothes. We're on the move a lot. Whether it's jumping from meeting to meeting or catching a flight or a dinner out, the Roan commuter collection has never let me down. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. Head to roan.com/legalaf and use promo code legalaf to save 20% off your entire order. That's 20% off your entire order when you head to RHONE.com/legalaf and use code legalaf. It's time to find your corner office. And then if they want to have an evidentiary hearing about this, the judge is going to then take all of the evidence that's before him, including the Bailey subpoena as modified by the judge. And he's going to say the following. Let me just project what Judge Engoron is going to say. Okay. Let's go through the checklist of things that would require my disqualification or recusal. Ex parte communication on a substantive matter with parties involved in this case or their lawyers without me having disclosed to the parties that it happened. That didn't happen here. Mr. Bailey doesn't represent Mr. Trump, is not a lobbyist for Mr. Trump, he's not a party to this case, and I don't have to disclose I had a contact with a general member of the public who regularly appears in front of my court to kibitz about the Trump case. This is New York. New Yorkers of various stripes kibitz about legal proceedings like they're talking about baseball or sports. Happens on the subway, happens over lunch and a sandwich in the park, and sometimes it happens when you see the judge presiding over the case. And so the judge did nothing wrong. Secondly, appearance of impropriety. There can be no appearance of impropriety. Since I didn't ask for the advice, I didn't use the advice, none of his legal advice, if you want to call it that, ended up in my decision or influenced my decision. In fact, it went the other way. He talked about Donald Trump in a way that suggested that I should rule against Donald Trump, and the court did not rule against Donald Trump, or rule for Donald Trump, if you will. So there's no grounds for that. And in terms of ex parte or improper lobbying or communication between my office, my chambers, and Mr. Bailey's law firm, you got the subpoena. I gave you the subpoena. There is none. Denied. And that will set the proper framework and foundation and a record for Donald Trump when he takes this inevitably to the Manhattan Appellate Court, the First Department, for the First Department to also reaffirm Judge Engoron's status as the presiding judge and do not do anything to vacate the decision and order. If Donald Trump's going to get that decision and order reversed, he's going to have to do it on other grounds. Now, he's got other appeal grounds. He's arguing that the appellate court gave direction to the trial court before the trial started about which transactions were inside or outside a statute of limitations. In other words, were too old or stale to be considered as part of the evidence. And they're going to argue the judge did it wrong. The judge included on the continuum of transactions certain things that were wrong. Okay, that's an argument that you can have in good faith in front of an appellate court, that the trial judge didn't properly apply the mandates and the rules and the rulings by the appellate court. Okay, but this other stuff, Judge Engoron is corrupt. Judge Engoron is disqualified. Judge Engoron has an appearance of impropriety. Judge Engoron's wife is a Trump hater. Judge Engoron's law clerk is dating an elected official, which is a lie. Judge Engoron is co-judging the case with his law clerk. Good luck. Those are all loser arguments at the appellate level. The judge, as we know, listened to dozens and dozens of hours of testimony, hundreds of hours of testimony by dozens and dozens of witnesses, including those who had the last name Trump, including Donald Trump himself, and evaluated thousands and thousands and thousands of exhibits provided and admitted into evidence, both on the Trump side and on the New York Attorney General side. And he weighed that evidence as the only trier of fact, because there was no jury, because the statute that is applicable for disgorgement of persistent fraud in New York doesn't allow for a jury trial. They could have argued for a jury trial, but they would have lost. And the judge, it rises and falls with the judge, as it has since the 1950s, and since case law amplifying the power of the Attorney General under this executive order, executive law that I'm talking about, that was established in a case that had Donald Trump's name in it. This is all a distraction, because when bad things happen, Donald Trump lives by the adage, make them happen slower. And that's all we're watching. At the end of the day, that judgment is going to stand just like E. Jean Carroll's judgment for over $100 million for punitive damages and sex abuse and defamation is going to stand. And Donald Trump's going to have to take a lot of that money that he's grifted from his followers on Truth Social stock purchases. He's going to have to use that to pay the people of the state of New York back for his persistent fraud over 10 years and pay E. Jean Carroll and others. That's just the way it's going to come down. But I love the confidence, the machismo, if you will, of the judge to say, you want to talk to Mr. Bailey? You want to see all of his documents? Go ahead. Because you don't have grounds to disqualify me, so I'm not afraid of anything. Go ahead. And we're going to continue to follow how the criminal justice system is trying its best, at least in the hands of competent judges like Judge Engoron, Judge Merchan, Judge Chutkan, the D.C. Court of Appeals, to restrain an out-of-control, rogue, criminal candidate for the presidency. That's what we're watching. And that groaning you hear is the groaning of our criminal justice system, devised by our founding fathers fundamentally, straining under the weight and the pressure and the attacks of Donald Trump and his MAGA legion. That's all we're listening to. And we'll call it out right here. We'll amplify it for you and explain it to you on the MeidasTouch Network and on YouTube, on a show, on a podcast we call, wait for it, Legal AF. Now you know why Ben and I named it that 4 years ago. We sit at the intersection of law and politics. We bring you a show that curates the top 4 or 5 stories at that intersection every Wednesday and Saturday at 8 p.m. Eastern Time, right here on the MeidasTouch YouTube channel, and then on every major podcast platform you can think of. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.